Alright, so YNW Melly, that's a name I haven't talked about on this channel in a while. If you've been rocking with me for a minute, you know that almost 3 years ago, I covered the YNW Melly trial day by day all the way through until it ended in a mistrial. And back then, I knew it might be a while before we talked about Melly again, but I didn't think it would be 3 years. Now, Melly and his double murder case are back in the headlines. Why? Because his retrial is now set to begin in September of this year. And because Melly has been fighting for bond for over 6 years. Let that sink in. He hasn't been convicted of anything, but he's been sitting in jail for 6 years. That's absolutely wild to me. Now don't get it twisted. I'm not saying I think Melly is innocent. What I am saying is that sitting in jail for 6 years without a conviction is insane. Yes, I do understand that sometimes people need to be held before trial, especially if there's a flight. Risk but 6 years, either convict him or let him go. That's how I feel, but my opinion doesn't change the facts. In December of 2023, Melly's defense team actually filed a motion for continuance. In that motion, Melly waived his constitutional right to a speedy trial. Now that might sound like a mistake, but in legal strategy it can be smart. It gave both the defense and the prosecution more time to prepare without being locked into Florida's usual 180-day trial deadline. That decision, however, also led to major delays. The retrial was first rescheduled for October 2023, then postponed again. Now it's finally set for September, but here's where it really hits. Because of all those delays and that waiver, Melly has now been locked up for 2,276 days unconvicted. And outside of pleading for bond, there's not much else he can do but wait for trial. He's facing charges for the 2018 murders of his two close friends, YNW Juvie, aka Christopher Thomas, and YNW Sackchaser, aka Anthony. William Sackchaser, also known as Anthony Williams. That was one of the two alleged victims in the YNW Melly case. The government claims that Melly, along with co-defendant YNW Bortlin, real name Cortland Henry, staged the crime scene to look like a drive-by shooting. And that's why Melly is still in custody. He's facing 2 counts of first-degree murder charges that could carry the death penalty if he's convicted. Prosecutors are arguing hard to keep him locked up, and not just because of the severity of the charges. They also say Melly poses a major risk if released. While in custody, he's been accused of witness tampering. Those claims stem from Mariah Hamilton, Melly's ex-girlfriend, and her mother, Felicia Holmes, according to prosecutors. Melly used intermediaries to communicate with alleged gang members, trying to pressure both women not to testify. They say this was part of a coordinated effort to obstruct justice in the ongoing trial. And that's one of the main arguments they're using, that if Melly is released, he could continue trying to interfere with the case. They're also saying Melly is a flight risk. He's a successful artist with money connections and the means to disappear if he wanted to. Plus, from a public safety standpoint, they say he's too dangerous to walk free. But Melly's defense team is pushing back. They've proposed strict release conditions, house arrest, 24-hour private security GPS monitoring, and his record label is even ready to post bond on his behalf. Still, the judge has denied bond before, and his latest request is still pending. That brings us to new footage from the courtroom where we see Melly's defense team and prosecutors going back and forth over whether or not he deserves to be released. Let's take a look at that exchange.
No law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight. Is he a risk of flight? So going through that, what we would be proposing for Mr. Demons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to. One it was twofold what I had asked for. Mr. Demmons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Demmons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. You basically have your own deputy, paid deputy, with him. Mr. Demmons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal, with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demmons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the time dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm.
Now Melly's asking for the same setup, except with one key difference. Melly's team is requesting a minimum cash bond. That means he's not trying to put up $1 million in cash, a bunch of real estate, or heavy assets. Why? Well, he's been locked up for 6 years at this point. We don't really know what his money situation looks like, but one thing's for sure. His legal defense is probably draining every dollar he's got. So instead of going big on money, they're offering everything else the court typically looks for: tight monitoring, security, and confinement. His defense is also arguing that 6 years in jail without a conviction is more than enough reason to grant bond. And when it comes to the flight risk concerns, they hit the court with, look back in 2019 when Melly was first arrested, he turned himself in. If he wanted to run, he had his chance. He also tried to downplay the witness tampering allegations, saying Melly didn't even know Mariah Hamilton was supposed to testify. He didn't interfere with anything. Bottom line, Melly's lawyers gave the best argument they could under the circumstances, but whether or not that'll be enough to get him bond, that's still in the judge's hands.
The case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard our motions. I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demmons' trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person, but there's no proof of it. We deal with, and I was based off the previous motion not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? and you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that. And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demmons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not did anything. He did the right thing, Judge, and he turned himself in. I believe February 13, 2019. 6 years ago. Spent 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counselor, I hate to interrupt you, but there's no evidence.
Okay.
The lawyers don't give evidence. So if you want to present some evidence, I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't consider it.
Okay, good.
You're just saying. So go ahead.
So, the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years, we're going now past 6 years. He has substantial ties to the community, to his mom, to grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That proof of degree, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those 3 things? To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demmons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we have met it. The state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant, is to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up at trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be.
Yeah, so that was pretty much their whole argument for why Melly should be released on bail. Of course, when the prosecution got their chance, Their best argument for why he shouldn't be was that Melly killed 2 people. He has committed murder. That could result in the death penalty, and because of that, he shouldn't be released.
In charge of homicide, he's killed 2 people, so he's clearly proven himself.
Allegedly.
He is.
These, one at a time.
He has already established that he presents a danger to the community, but not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody, because he did have a bond and that bond was revoked. Had Mr. Demons been on bond, his bonds obviously would have been revoked and he'd be back in custody as well, because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater, because it is going to be much more difficult to recover him should he leave the jurisdiction.
Okay.
May I respond, Judge?
Okay, last word.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. I'll give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be if there was a monetary bond in place. His record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we have conditions in place to ensure. As far as what the state's arguing that they're afraid he would flee, I again think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day, and another individual monitoring the property. They would be reporting back to not only the defense team, but the state attorney and to the court if there is any issue. Again, the ankle monitor is being monitored. I've had other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Demons, while being on house arrest and a GPS tracking monitor, had absconded to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those 3 different combined statutes. It's protecting the community, protecting the integrity of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
YNW Melly is hoping the judge grants him bond. But I'm not gonna lie, when his lawyer brought up the record label putting up the money, the judge wasn't feeling it. You could literally see him shaking his head while she spoke, and then he looked directly at Melly. It kind of seemed like Melly realized right then, this judge is not going for it. And honestly, why would they grant bond now? They've denied him for 6 years straight, and let's not forget, they gave up his right to a speedy trial. That decision is partly on him, or at least, that's probably how. The court sees it. Now everyone was hoping for a decision on the spot, but the judge said he needs a few more days to think it over. So we're still waiting. I'll definitely be watching closely. Y'all already know, as soon as that decision drops, I'm gonna bring it straight to you. But for now, that's what we've got. Let me know what y'all think. in the comments down below. Was Melly's bond request solid, or is it just too late? If you enjoyed the content, make sure to hit that like button, subscribe, and tap the notification bell so you never miss a video. As always, it's been real rocking. With y'all, this one gave me flashbacks to when I covered Melly's trial the first time around. But anyway, I'm out. Peace.